Questions are hinged on two issues. Rather, I'll focus on two issues. One, the ineffectiveness of the notice. The notice on the notice of the chief registrar, of the deputy registrar. Ineffectiveness of the service of this notice, my lord. My lord, for the record, this notice is provided for under Section 28 of the TIA. There is no any other law that provides for a notice to be signed by the registrar. Section 28. Much as the registrar did not indicate under under which law or the particular provision of the law it's being brought. Unless, my lord, the court has a different position on this, that it could have been brought under any other law. But from our understanding, it's brought under Section 28 of the TIA. And Section 28, my lord, has a heading note, we call a marginal note. It's about form of indictment. It's about indictment. Form of indictment. And 28 has got two documents. In subsection 1 of 28, it talks about the form of the indictment, and the template is there in section 28. The template of the form of that particular indictment is provided for in subsection 1 of section 28. That is the template. Now, after that indictment, following this template, you come to subsection 2, which provides for the notice. And these are the two documents here. The actual indictment and the notice. So, therefore, my lord, this notice is clear. It must be served on the accused persons, not less than 14 days before trial. First of all, it talks of reasonable notice, but not less than 14 days. Reasonable notice. The operative word, first of all, is reasonable notice. First of all, reasonable notice. Reasonable notice. That is the operative word, my lord. Look at the absurdity, and this is the point my learned friend Impanga was trying to emphasize. The absurdity of this notice, my lord. The registrar is commanded, or court is commanded to give reasonable notice of the trial. my lord, you ordered that the amendment be effected within 5 minutes, and within 10 minutes there should be service, and that was before midday. The fundamental question to be posed, my lord, and this point was raised by my Maryland friend in Panga, and I want to emphasize, if time for trial is fixed at 12:30 and service is effected at 1 p.m., like it is the case here, is there service? Is there service? We are saying our answer, I mean, we are answering that in the negative, that there was no service. First of all, we're not talking about reasonable notice. We're talking about notice at all. Is there notice? No. There was no service at all. And there was no, even they had no courtesy of asking for leave of court to serve out of time. My lord, the court orders are not made in vain. The order to serve within 10 minutes was a court order. So there was no notice to begin with. There is no notice. There is not been service. And that is a violation of Section 61 of the TIE. Because that must be served. It has not been served. Coming to reasonable notice, my lord, because the first segment of the first limb of my argument was that there was no notice at all. But coming to reasonable notice, my lord, even if one were to stretch it to those levels, I mean, levels of, to be magnanimous enough to say, okay, fine, would be an oversight on their part. Is there reasonable notice where the chief, the registrar notifies the accused persons that, look, today at 12:30, you are going to be tried. What a travesty. My lord, again, I want to reinforce the submission of Mr. Mpanga on the question of trial. I think there should be no misconception or misconstruction in regards to this particular phenomenon of trial. Because in this, the notice itself speaks, the notice speaks for itself, my lord. Says, take a notice that you will be tried on the above indictment at the session of the Criminal Division of the High Court holding at Kampala on the 30th day of December at 12:30. Take a notice that you will be tried today at 12:30. Dated today. So the notice given by the registrar to the accused is for trial. That's what it says. Take notice, you will be tried today at 12:30. So they are here for trial. And my lord, my land friend Frederick Panga referred to you, cited some authorities. I would like also to refer you, my lord, to my lord, I would like to refer you to this authority about fair trial, Uganda Law Society. It's a constitutional Uganda Law Society versus and another, sorry, Jackson Karugaba versus the Attorney General. It's constitutional petition number 2 of 2002. I think they were consolidated, there were two. Constitutional petition number 2 and 8 of 2002. My lord, the fundamental issue in this particular case, the bone of contention, was that, and this is what the court said, the gist of the argument is that the trial was too speedy, that it was not possible to give the accused persons the safeguards they were entitled to under the law. This was in the trial of Corporal Medio and others who were subjected to trial, a summary trial of 3 hours, and shortly thereafter executed in Karamoja. And the Constitutional Court had the occasion to revisit this matter, and specifically on page 17, made the following finding. The issue is whether this was a fair and speedy hearing envisaged in Article 28(1) of the Constitution. In order to understand the meaning of this mandatory requirement, we have to look at the relevant provisions in the whole Constitution, but also the entire provisions of Article 22, 28, and 44C of the Constitution. Can what is required to be done under those articles be accomplished in a matter of just 3 hours? Surely, when considering the requirement of a speedy trial, speed must be measured against the requirement that the trial must be fair in all other aspects spelled out by the Constitution. And they concluded by saying that speed must be reasonable. Speed and reasonable speed must be measured against the overall objective of achieving a fair trial. In my opinion, this trial was not conducted in accordance with Article 28. The process was a clear contravention of that article. My lord, the instructive prejudice then I hear is that speed, yes, in as much as we are talking about speedy trial, speed must be reasonable. My lord, in this particular case, service of a notice within 10 minutes and done after the time fixed for the trial has passed. If it were the speed on the road, that would be, with all due respect, recklessness. So that is not reasonable, my lord. It defeats the purpose the notice was intended to serve. I'm concluding, my lord. It defeats the spirit and the purpose the notice was intended to serve. That is giving the accused persons ample time to prepare their defense and also understand. So the last one, my lord, is subsection 3 of section 51, my lord, comes into play, because the order you made was under subsection 2 of section 51. But our contention is that, my lord, your order has been abused by the prosecution, because under subsection 3, the alterations had to be endorsed on the indictment already on record. This is what the provision says. That where an indictment is altered under subsection 2 as you are directed, a note of the order for alteration shall be endorsed on the indictment, and the indictment shall be treated for the purposes of all proceedings in connection as having been filed in altered form. They have instead substituted the original indictment. They have actually filed a fresh indictment altogether. Even the altered parts have not been marked as required. That these are the changes effected. Nothing. Actually, you have now two sets of indictments on record. One which was filed on 25th of May and not 29th of May and not signed by the registrar. And now a new one. My Lord, I was trying to look for the word amended. I don't know, somebody can guide me. My Lord, yes. There are two now sets. Which parts have they now amended? Yes, I've seen it on the top here, my Lord. But the amendments, we don't know, my Lord, what has been removed and what has been left intact as required. So instead, they have substituted the indictment, which is a violation of the order you had earlier on given, as well as the provisions of section 51. My Lord, at the conclusion of the submissions later on, my colleagues will raise some housekeeping issues. But some housekeeping issues, they will be raised. Most obliged, my Lord.